Now there is a case that I'm convinced that all canine handlers, when they go through basic canine school, and I'm not a canine handler, I don't have any experience with it, but I'm convinced they're all taught this United States versus Anchondo case out of the 10th Circuit, because I hear it cited very frequently as, well, yeah, I can search the car and the people if the dog alerts on the car, especially if I don't find drugs in the car. So Anchondo is a 10th Federal Court of Appeals 10th Circuit case that said, yes, a dog alert on the vehicle coupled with not finding any drugs in the car is probable cause to arrest the passengers, which of course leads to a search incident to arrest. So it's effectively a search of the persons based on a probable cause alert on the vehicle. Now, a couple things about Anchondo. It's binding only on federal courts in the 10th Circuit. And one of the state courts in the 10th Circuit, I believe it was Kansas, specifically said, we're not going to follow Anchondo.
Right, it is. Yep.
It was a Kansas?
Yes.
Yeah, okay.
I think it actually might have been, I could be wrong. I think the case name might have been Johnson. Real quick question for you before you continue on is, I don't know, hopefully this mic is sounding good as a new mic. I could hear it's like make some weird noises over here. But one question for you is this. I don't want to dissuade people. Is it true that some states have adopted a per se almost bright line rule with the odor of marijuana to search persons inside the car? And I just want, in case anybody's engaged and they're already coming up with this, oh my God, but our court said this. Relax, we're going to explain that as we go along. So let's go back to Anchondo. You said absolutely, right?
Yeah, absolutely. And I believe New Jersey is one of them.
Well, it was.
right. Until the legalization, right. But yeah, so finishing up on Anchondo, there are a few state courts that have said, yep, Anchondo sounds good, we'll follow that. But the biggest problem that I have with Anchondo, other than it's not consistent with U.S. Supreme Court case law, is that it is a very brief opinion. If you read Anchondo, it is very brief. It gets to the point and says, yeah, the search in this case was lawful under search incident to arrest theory, but it lacks any meaningful analysis as to why the court held the search was lawful. And that's really the key in all case law, is the analysis. So the holding of the case, it was a lawful search, is important to the litigants of this case, the particular people involved in this case. Yeah, that, at the end of the day, they want, was it good or a good search or not a good search. But for the rest of us who are now relying on this piece of case law for future cases, it's the analysis that's important. So if a court were going to reference Anchondo as, well, we've never had this issue in our state, so let's see what other states and other federal courts have to say about it, Anchondo is not going to be a case that's going to be given much consideration because it has no analysis in it. So yes, it's binding on federal courts in the 10th Circuit. I believe it's inconsistent with Supreme Court case law. I would not put any weight on Anchondo if you're not in a jurisdiction that has not already adopted Anchondo's holding, which there are very few. The vast majority of states that have addressed the issue have gone the other way and said, no, you need more than just the dog alert or just the dog alert and not finding drugs in the car.
Mm-hmm.
So,
now we clearly know that some states have adopted it. People ask me this question all the time. Did my state adopt it? What would be a good way of researching if your state has adopted the ruling found in Anchondo, or regarding, the ability to search people after a canine alert? It's interesting. I'm going to jump in here real quick because I don't want to lose train of thought. But when I taught last week in Kentucky, basically the ruling in Kentucky, and I don't expect you have read it because it was very specific to the Kentucky area while I was teaching Kentucky/Ohio law in tandem. They said basically they wanted to see the canine alerts while people were sitting in the car. If you did that, well, then they can articulate. And they actually said when you did that, because of where the dog alerted and the passenger side door where this person was sitting, it was reasonable to believe that the person could have had the narcotics in their person. So I try to give guys examples of, if this is what they say they want and why they said this was good, well, this is what you're going to have to find. So this articulation beyond just a canine alert, we've talked about this before, you and I, whether it's publicly or privately, people have to understand how to articulate what they're trying to do. So from that point forward, you can go ahead and begin to, I can see you're on the edge to talk.
Yeah. I mean, so yeah, that it sounds like, and I'm not familiar with that particular case, but yeah, it sounds like it's more than just what Anchondo said. You had the people in the car with the alert, and then it's alerting to a particular location in the vehicle. So kind of the anti-Anchondo case, if you will, what I would consider the leading court, because the U.S. Supreme Court has never had a case like this. D. Ray is from 1948. It's still good law. It's an old case, but nothing involving drug dogs like this has come up.